I'm going to order you one more time. I do not find that persuasive. In fact, I find it manipulative. I'm going to order you one more time to remove your hat out of respect for the court as I order anybody else, so as not to treat you differently. I do not find your reasons to be persuasive. I'm going to order you to do it. And I just wanted to let you know that failure to comply, I will find you in direct contempt of court. Do you understand that?
As long as you...
A judge stares down at a man in a black winter hat and delivers an order so simple it should never have needed repeating. I do not find that persuasive. In fact, I find it manipulative. The man does not move. He tells the court he needs the hat to keep his power. The judge warns him that failure to comply means direct contempt, right there, on the record, in front of his own attorney. The man nods. He does not take off the hat. What the judge does next will determine whether a piece of fabric is worth a night behind bars. By the end of this video, you'll understand exactly how a judge can jail someone without a jury, a trial, or a single new charge, and why that power exists. The case unfolded in Boulder County, Colorado, involving two combined dockets, case numbers 24M2519 and 25M312, against defendant Mr. Richmond. Richmond appeared before the court for a pretrial readiness conference ahead of a scheduled jury trial. His attorney, identified in the record as Mez Bulkowski, stood beside him. The presiding judge ordered Richmond, as is standard courtroom protocol, to remove his hat before proceeding.
All right, ladies, Mr. Richmond's two cases, 24M, 2519, 25M1312. Mr. Richmond, come on up, join your attorney, please. Mr. Richmond, would you please remove your hat in the courtroom?
Like I said earlier, Your Honor, I'd prefer for spiritual reasons not to.
Not cultural reasons.
Cultural.
Before any of this became a legal question, Richmond was simply a defendant awaiting trial, someone who had already spent time navigating pretrial hearings, coordinating with counsel, and preparing for a jury that would decide the outcome of his actual case. A contempt finding adds nothing to that underlying prosecution, but it does add something else, a criminal record entry that exists independent of guilt or innocence on the original charges, and a night in custody that costs him freedom over an object weighing a few ounces. The court's order was simple, repeated, and unmistakably lawful. Removing headwear in a courtroom is baseline decorum, and judges enforce it uniformly, regardless of who sits at the defense table. When Richmond first offered a spiritual justification, the judge asked him to explain it. Richmond hesitated, then pivoted, calling it cultural. Most viewers watching this exchange focus on the hat itself, but the detail that actually mattered was the switch in language, spiritual to cultural and back again, without ever landing on one coherent explanation. That inconsistency would matter far more than the hat.
Are spiritual reasons, are they not? Or spiritual or cultural?
Would you describe that to me further?
It's to my understanding, sir, that many people do not need to remove their hat.
I'm asking about your situation. Explain it to me.
Yes, I believe mine is similar because spiritually, I believe I lose power when I expose my head fully. So I'd prefer not to remove my hat because I feel like I need power in here.
Okay.
Direct criminal contempt exists under statutes and inherent judicial authority that let a judge sanction conduct committed in the judge's presence, without a separate trial, because the offense, defying a lawful order in open court, is witnessed firsthand. In plain terms, a judge doesn't need a jury to punish someone who breaks the court's rules directly in front of them. The next few minutes would answer whether Richmond's belief was sincere enough to test that authority or too inconsistent to survive it. The judge asked Richmond to explain his reasoning again. Cultural or spiritual, are they not one and the same? Richmond stumbled, then claimed exposing his head fully caused him to lose power. The judge told him plainly, "I find it manipulative." Richmond was warned a second time, then a third, each warning followed by the exact same explanation, delivered with no more clarity than before.
You feel, as long as you understand, you're asking me to yield my power spiritually in a literal sense. This is what you're doing. This is what you've done last time. This is what you guys always do. And, you know, I think that's really...
I don't understand your answer. I'm ordering you to remove it again with you understanding the consequences. Do you understand the consequences of failure to remove your hat?
Can you please explain them?
Yes, I will hold you in direct contempt of court, finding that after repeated warnings, you failed to comply with the court's order and that it undermines the dignity and the authority of this court. And specifically, I don't find your reason to be persuasive. Do you understand?
When the judge finally noted for the record that the hat shows no signs of any cultural or religious affiliation, it was the single sentence that ended any ambiguity.
Response to my final order to remove your hat.
Sir, I really insist on this, and I feel really strongly spiritually about it, and it's time for me to take the consequences of that.
The court has found that now find that the defendant has been warned multiple times to remove his hat. He's been given sufficient notice and given a direct order, in fact, to remove his hat. He is explained, and the court finds it to be completely incredible, having even changed his explanation after talking with his attorney, explained his heartfelt, that's with air quotes, reason for not removing his hat. I find it to be incredible, manipulative, and in direct contempt of the court. I find that it undermines the authority and undermines the dignity of the court. I find that he does so intentionally. And because of that, he is in direct contempt.
A generic winner cap, unconnected to any identifiable practice, undercut the entire justification. If Richmond had wanted an accommodation, the moment to request one was before the hearing through his attorney, citing an actual religious exercise claim under the First Amendment's Free Exercise Clause, not invented mid-hearing under pressure. A properly prepared defense would have raised the request in writing beforehand, giving the court time to evaluate it seriously. Instead, the explanation shifted in real time, and that improvisation cost Richmond a day in the Boulder County Jail, a sentence that, however brief, still meant lost wages, a night in custody, and a jury trial now approaching under a judge he had just defied. Nobody is formally disciplined for failing to raise an accommodation properly ahead of time. That failure falls entirely on the defendant.
That leaves the contempt. Regarding contempt, Ms. Volkowski, do you want to be heard, or you want your client to be heard, or what would you like to do?
One moment, Your Honor.
Yes.
Your Honor, unfortunately, I don't have anything to add to the record.
Most people assume a judge holding someone in contempt is acting punitively on impulse. That is not what the law requires. Contempt exists specifically to preserve order, and judges are trained to apply it only after clear, repeated warnings, which is exactly what happened here.
Not fully, so do I
So
get
let me
to wear
think.
my hat next time? That's what I'm trying to understand.
I'm talking about this time. We'll worry about next time. Do you understand that if you fail to comply, I will hold you in direct contempt?
So I'm going to be held for 24 hours while it's cold out?
I have no idea what the consequences are going to be. You will be sentenced on direct contempt, and I'll allow you to make any statement you want in mitigation. I'll hear from your attorney as well, and then I'll decide. You may not go into custody at all, or you may, or there may be some other consequence.
Okay.
What is your response?
The judge sentenced Richmond to 1 day in the Boulder County Jail, explicitly noting the sentence was restrained given the circumstances.
Okay. Mr. Richmond, you're given the opportunity, and you can just stay right there, to tell me anything you want before I decide on the sentence or the direct contempt. If you want to say something, you may. If you don't, that's fine too.
I don't want to say much, but I mean, all there is to say that it's like a religion to me. It's personal. It's semi-parallel to what a lot of religions and cultures believe. And if I embellish too much, then that would be, I believe, wrong.
If you embellish, mean add more to it?
Yeah, like that is part of my belief.
Okay, I got it.
And that is part of, call it spiritual, religion, cultural. I don't care what you call it.
This is the same inherent contempt power that lets American courts function without collapsing into disorder every time someone disagrees with an order. A principle dating back to the earliest common law courts. A courtroom cannot run on selective compliance. The rules apply the same way to everyone in the room, or they apply to no one. What happened to Richmond over a hat will happen again to anyone who mistakes personal belief for legal exemption without ever asking the court first.
As far as I recall.
Deputy, yes, Deputy, Mr. Richmond, he's going into custody.
Just wait for me, please.
He's been very cooperative with me other than the contempt piece. This is a record.
Next slide. We examine what happens when that same defiance follows a defendant into an actual jury trial, and whether a judge can remove someone from their own hearing. Was Richmond's explanation a sincere, if poorly articulated, personal belief that deserved more patience from the court, or was it a manufactured excuse that the judge was right to reject outright? And if courts start giving deference to claims like this, where is the line drawn next?